With the rise of a digital scam, the topic of individual privacy has never been more critical. But why all these scams are growing day by day? The reason is accessibility of your data that happened due to data leaks. By the way, if you wish to know where and what data of yours is being traded on dark web, you can check it through myactivity.google/dark web report/results. Just log into your Google account under the dark web report and click Start Monitoring. You need to select what information you wish to monitor, and voila, your report is ready. Coming back to the topic, to tackle this growing concern, the Government of India has introduced the Digital Personal Data Protection Act. This act aims to strike a balance between the protection of individual privacy, responsibility of business owners, and their legitimate need to process the individual data. In this video, let's break down this act and see what are the rights you have as an individual and how this act tries to prevent leakage of data. This video is divided into 7 parts which are time-stamped, and you can jump to the section as per your wishes. This act protects our privacy. Let's see what privacy actually is. In Justice Puttoswamy versus Union of India, the Supreme Court has brought the importance of privacy into legal discussion. It made the privacy a fundamental right under Article 21. Court went into the length and breadth to discuss and define what privacy is and the need of it for an individual. In this case, 9 judges bench defined what privacy is according to themselves, and in my humble opinion, definition of Chandrachud sums it up very well, and it contains the comprehensive definition encompassing the opinions of other judges. If you wish to read or understand this judgment, I highly recommend the series of articles written by Gautam Bhatia. Now, according to Justice Chandrachud, privacy has 3 facets. Number 1, spatial control. Number 2, personal choice. And number 3, control over personal information. Spatial control refers to the concept of maintaining seclusion of both body and mind, ensuring that there are no external influence compelling an individual to act in a specific way. It is about creating an environment where a person's thought and action are free from any external pressure or stimuli. Personal choice refers to the freedom to make an intimate and personal decision. According to the court's opinion, this freedom can only be fully realized if one has a spatial control over their mind. This means that to make genuine personal and intimate decision, an individual must be free from external influences. Only one is not swayed by outside factor can truly exercise their personal choice. And finally, control over personal information, meaning having the right over the data that can uniquely identify you, such as your name, gender, or political beliefs. This control allows you to decide who can access your information and how it can be used and for what purposes, ensuring your privacy and autonomy in a digital landscape. Before we explore this act, let's look into some essential definition that will help us to decode this law. Number 1 is consent. Consent is defined as freely given, specific, informed, and unambiguous indication of the data subject's wishes. This is demonstrated through a clear affirmative action signifying the agreement to process the personal data. Number 2, data fiduciary. This refers to any person, which includes individual, companies, or state, that determines the purpose and mean for the processing of the data. Number 3, data processor. A data processor is defined as a natural or a legal person, public authority, agency, or other bodies that process personal data on behalf of data fiduciary. For example, let's say there is an online retail company, ShopSmart. ShopSmart collects personal data from its customer, such as their name, email address, delivery address, or purchase history. Now, ShopSmart can process this data itself or could hire a third party to do this processing. Let's say store it. Now, in cases where ShopSmart is processing this data itself, it will act as a data fiduciary as well as data processor. Whereas if they hire store it to process your data, it will act as a data fiduciary, whereas store it will act as a data processor. Number 4, data principal. Data principal is an individual whose data is being processed, meaning you, me, or anyone else whose data is being processed. Number 5, personal data. Now, personal data defines the data that can identify you or it is related to such data that can identify you, meaning any details that can identify you directly or indirectly. For example, your name, your gender, your address, your phone number, email, or any political beliefs or preferences. Number 6 is processing. Processing meaning performing any action like collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment, indexing, etc. as you can see on your screen. These actions can be automated completely or partially. Now let's explore the rights that we have under this Act. Chapter 3 lists down the rights we have under this Act. Number 1, right to information. You have right to obtain information about the processing of your data, including what data is being processed, what data is being used, and who is the fiduciary. Under this Act, you can ask for the summary of your personal data that is being processed. Along with that, you can ask for the list of all data fiduciaries, individuals, and organizations that are involved in the processing of your data. Number 2, right to correction and erasure. You can request the correction of inaccurate data, updating of your data, and request for any erasal when it is no longer necessary. The Act mandates the data fiduciary or data processor needs to delete such data once they receive a request for it. Number 3, grievance redressal. The rule mandates that data fiduciary must publish a grievance redressal system as well as the period within which they will respond to the grievances. Number 4, right to nomination. Under this Act, you have right to nominate another person to exercise your right under this Act. In certain cases, when you cannot exercise your right, that could happen due to death or incapacity. Now, these were the direct rights that are defined in Chapter 3. Following are inferred rights that you have. Number 1, right to be forgotten. In order to process your data, data fiduciary needs your consent. This consent is given for a specific purpose and for a specific time. And once this time is over, or you have withdrawn your consent, your data must be forgotten. Number 2, right to information on data breaches. You have right to be informed of a data breach of your personal data by the data fiduciary or data processor. Along with the rights, the Act lays down some duties for an individual. That is, number 1, you need to comply with all the applicable laws while exercising your right under this Act. Number 2, you should not impersonate another person while providing your data for a specific purposes. Number 3, you must not suppress any material information while providing your personal data. Number 4, you must not register a false or a frivolous grievance or a complaint. And number 5, furnish only information that is verifiable and authentic while exercising your right of correction or erasure. Let's see how this Act functions. And in order to understand this, let me take the previous example of ShopSmart. ShopSmart needs to deliver a product to its customer, say Rahul. In this case, ShopSmart is required to deliver a notice to Rahul in a simple language informing that they require his name, address, payment detail, and phone number. This notice shall also list down other information that are all the personal information ShopSmart is required. Number 2, reason for such requirement. Number 3, duration for which it is needed. Number 4, mechanism through which Rahul can exercise his rights as we discussed. And number 5, grievance redressal mechanism to resolve any issue that Rahul may face. After receiving this notice, Rahul requires to show his willingness to process his personal information, and only then ShopSmart can collect or store his data. Now let's see provisions to provide protection against data leak. There are various ways to ensure this and can be summed up into 3 broad categories. Number 1, security safeguard. Number 2, personal data breach notification. And number 3, right to be forgotten. Under security safeguards, company needs to implement a reasonable measures such as encryption, access control, and audit logs. They are also required to tokenize the personal data. Companies must maintain a visible access control mechanism to prevent unauthorized access to the personal data and also create logs so that they can monitor and detect any unauthorized access. Additionally, data fiduciary must conduct data protection impact assessment and audits every 12 months to ensure compliance with this act. Upon failure to do so, a data protection board can impose a penalty up to 250 crores if found guilty of negligence. Notification: a company must promptly notify each affected individual of their data breach, detailing the breach, its impact, risk mitigation measures, and safety steps for such individual. Additionally, companies are required to report such breach to the board or a supervisory authority, providing information on the nature of breach, extent, timing, location, and potential impact. This notification must include description of the breach, the contact detail of data protection officer, and likely consequence. Finally, they also need to inform the measures that are taken to address this breach. If companies fail to comply with this provision, they may attract the penalty of 200 crores. Under right to forgotten, companies are required to erase personal data when it is no longer needed for its original purpose, ensuring that redundant data is not retained indefinitely. Additionally, the companies must delete your data once you have withdrawn your consent. Failure to comply with this rule can result in penalties up to 150 crores. The Act also empowers Data Protection Board to inquire into data breaches and impose penalty for various violations of this Act. This is the small summary of rights and provision to protect individual against processing of their data by private organization and state. The Act emphasizes upon individual consent before processing of any information provided by such individual. But at the same time, Act also empowers state or government to collect and process your data without your consent in certain cases. I have not touched upon various aspects of this Act in this video, like how this Act protects children's right, or what are the obligations for companies, what is significant data fiduciaries and their role, and how this Act is different from GDPR. And I will be posting few more videos on this topic to comprehensively covering this Act. So I request you to stay tuned and subscribe to my channel. If you think you learned something and may learn in future, do let me know in comments. And tell me how I can make these videos more interesting and at the same time enhancing our knowledge base.